Thank you. Thank you, counsel. Next up is Jahanbin versus the Boeing Company. I'm sorry for that name.
Good morning, Your Honors. May it please the Court, Aaron Orheim here on behalf of the appellant in this case, Shahrooz Jahanbin. I'd like to reserve 2 minutes for rebuttal. Your Honors, our Supreme Court instructs us that summary judgment for an employer is seldom appropriate in an employment discrimination case because of the difficulty of proving discriminatory motivation. Here, the trial court should be reversed because, in this case, because Shahrooz Jahanbin supported a prima facie case for disparate treatment, discriminatory discharge, and termination of violation of public policy. Boeing admits that it deviated from written discipline policy, and a jury could infer
Don't we have a declaration that says where we think that the conduct rises to a different level, we have a different mechanism per our policy, and that's the SAR?
That's the SAR, Your Honor. Is that the 2F justification? The 2F justification, which says that it usually results in time away from work, and Boeing says, that's creating the liability for the company. Mm-hmm. Boeing says that usually results in time away from work. In this case, Jahanbin was disparately treated, investigated covertly, and then terminated. And in Boeing, the limited data that Boeing has turned over says that Boeing routinely deviates from that written policy, where it says that 18 of the last 21 2F violations have resulted in termination. So clearly it doesn't result in ordinarily time away from work, it results in termination. And based on some amorphous criteria that a jury must assess, a jury must hear Boeing's justification for its actions and determine whether that's credible or whether that's...
So you're getting to the ultimate question with regard to summary judgment. We have to first do that McDonnell-Douglas back and forth, right? So right. You've asserted that your client made his prima facie showing with regard to discriminatory conduct. Right. Assume that we agree with you, then we shift over to Boeing's burden to provide a non-discriminatory reason for this adverse employment action. So talk to us about why in your view that burden was not met.
Wilmot says, Your Honor, that even if Boeing can supply some sort of justification that doesn't defeat summary judgment.
No, because then we swing back again.
A jury can still infer whether that justification is pretextual or whether that discriminatory motivation still was a substantial factor.
Provided that swing back is addressed, right? So
Boeing has said the 2F violation, so let's just say Boeing says the 2F is a justification. Well, we know that a jury could find that that's pretextual because we know that Boeing is already deviating from that very written policy in most of its cases. It's saying 18 of the last 21 violations have resulted in termination when the written policy says it should ordinarily only result in time away from work. We also know that, and then there's also the inferences from the record, which you must view, again, when doing this shifting, must view in the light most favorable to Jahanbin, not just taking that at face value and saying that's good enough to defeat summary judgment, which I think was the trial court's error in this case. But looking at all the other inferential facts that might be available to us, we have, and key in that is the disparate treatment that Jahanbin received. Disparate treatment in and of itself is evidence of pretext. Disparate treatment here, Jahanbin was not given a written warning when in the early months of COVID he downloaded Zoom and Microsoft Teams and Gmail to his personal laptop that he was using.
And that's emphasized pretty extensively in the opening brief, but the conduct that we're talking about went beyond that. I mean, based on the summary of the internal investigation.
The alleged conduct, the Boeing's side of the story maybe went beyond that, but
sure, and that's
Mr. Jahanbin has never been
right, which is not the test, but we're looking, de novo at what is in front of the trial court.
Yep.
When we're making this analysis, and I understand that there's emphasis on downloading certain apps, Teams, Zoom, things like that, but the conduct.
Communicating with professors in Iran while he's doing his school studies,
The conduct outlined in Boeing's investigation report that supported, from its perspective, its determination, this adverse employment action, went beyond merely downloading Teams and Zoom, from
Yes.
their perspective.
From their perspective.
Correct.
Conclusory statements.
Right, so under the McDonnell-Douglas framework, then they make their offer.
I understand.
And then your client has the burden to demonstrate by sufficient evidence
Yes.
that was pretext.
So, and here's what we use to evaluate pretext. Here's what I'm trying to get to, Your Honor. I don't mean to be confrontational, but the disparate treatment, that's evidence of pretext. The justifications, the over-exaggerations are evidence of
When you
pretext.
say disparate treatment, I mean, that is the claim. But what you're really talking about is comparators were treated differently. Is that what you're saying?
Which we weren't given the full access to comparator data. And yes, disparate treatment, I would say disparate compared to other employees. I would also say disparate in regards to Boeing's written policy for how it deals with employment infractions.
Let's talk about your 56F argument, because that is a key part that you're saying, well, we could have shown this comparator evidence, but we didn't get it. What did you have in the record before the trial court that showed that you had asked for information or that you had a reason for the delay?
Clerk's paper 793 to 992 is where we served discovery. Talks about where discovery was served 6 months prior to the summary judgment motion. Boeing responded and said that discovery is on just a few weeks before it moved for summary judgment. Boeing says, here's a batch of responses. Discovery is, quote, discovery production is ongoing and responses may be supplemented. That's CP 966. So ongoing discovery is still happening weeks before the discovery cutoff, which the parties agreed to by a stipulated motion to amend the case schedule. The deadline for discovery for dispositive motions is still 7 months away, trial 7.5 months away. They've been actively litigating a 12B6 motion. They've been conducting depositions. Boeing admits that.
Well, you
Discovery
didn't
is
get no
ongoing.
information. You got information, and that's kind of a standard line to say, yeah, discovery is ongoing. We
Yeah.
have an obligation to keep updating it.
We got information about terminated employees. We did not get the comparator data of those who received less discipline, less than termination, Your Honor. The information we did get, again, was sort of that, raised more questions than provided answers, like that those 2 F violators, 18 of 21 who were terminated rather than provided time away from work, which is what the written policy said that sort of provision should. We didn't get details about what exceptional liability those persons created for Boeing as compared to whatever Jahanbin did communicating with professors in Iran.
Aren't we ultimately, though, really talking about one adverse action, the ultimate discharge?
No, we also allege the disparate treatment, Your Honor. I would say
I know you allege that, but how is it adverse to
To
not
covertly-
be given a warning? I mean, nothing happened other than they investigated, which led to the discharge.
They installed software onto his work computer that took a picture of his screen every 3 seconds, and they monitored his activity for 8 months without letting him know, without putting him on a personal PIP,
Do you have authority
personal
that
improvement
says
plan.
that a private employer would have to advise their employee that they were under investigation? You can answer that on rebuttal.
Thank you, Your Honor.
May it please the court. There's no dispute that plaintiff uploaded export-controlled files to a third-party site, disclosed cockpit recordings and other proprietary information to third parties. We just heard counsel acknowledge that he's communicating with people in Iran. No dispute that plaintiff secretly recorded meetings between Boeing and the FAA, downloaded unauthorized software, and took multiple actions that Boeing found were designed to conceal his violations. This conglomeration of misconduct is why Boeing's Special Action Review Committee of Boeing vice presidents decided to terminate his employment. And there's no evidence to support plaintiff's claim that he was instead actually fired because of his national origin. Plaintiff cannot even get past the prima facie case stage of his claim because he admits to misconduct, showing that he was not a satisfactory employee, and
Let's
conceding.
talk about that.
Sure.
So you're saying we don't even get past step one of the McDonnell-Douglas test because he does not establish satisfactory work.
That's right.
Or any evidence of that. So, but you're talking about the very conduct that led to the discharge. Aren't we supposed to be looking at what came up to that point, before that point?
The prima facie case is designed to root out the most ordinary explanations for a discharge other than discrimination. The McKay versus Home Depot case, the Sim versus Department of Labor and Industrial Relations case, they both say that policy violations, misconduct may disqualify the prima facie case.
Right, but up to that point where they started investigating, he said nothing but
That's true.
good performance.
That's true.
Why isn't that enough for, just at the prima facie case level?
I
It just
can-
surprises me that you're arguing there when you.
I can only point the court back to its own issued opinions, which say that if he's engaged in
Which?
misconduct. So McKay versus Home Depot and Sim versus Department of Labor. I would also point out that in his reply brief, plaintiff did not dispute this or even address the issue of the prima facie case, and thereby conceded the point, which is State versus Ward. But even if plaintiff could get past his prima facie stage, there's no evidence that the discharge was motivated by national origin. Indeed, the claim doesn't make any sense. Boeing knew from the moment that it hired plaintiff that he had been born and educated in Iran, and yet plaintiff admits that he had a flourishing career for 10 years at Boeing, right up until the point that Boeing uncovered his misconduct. And plaintiff's own wife, also born in Iran, still continued to work for Boeing and may very well do so today. And Boeing's SAR committee, the Special Action Review Committee of Vice Presidents, made the discharge decision based on misconduct discovered by Boeing's strategic intelligence team. But there is no evidence in the record that anyone on the SAR committee or even anyone in the strategic intelligence team had any national origin bias whatsoever.
So you can show, though, a claim sufficient to withstand summary judgment if you've got evidence of animus, if you've got direct evidence, very difficult to find. We do have here that part of the investigation involved the fact that he spoke Farsi, right? But ultimately, what is your response to the lack of the comparator evidence? And that seems critical. I mean, that is circumstantial evidence, right? It's how you get there if you don't have the manager saying, we don't like him, he's Iranian, right?
Well,
Isn't the comparator evidence?
comparator
linchpin?
evidence is important, and there is none. And
Because
so,
you didn't provide it as your opposing counsel's position.
in the ordinary course of discovery, plaintiff asked for certain things. There was a motion to compel when he didn't like the response that Boeing gave, and the motion to compel was denied because plaintiff didn't participate in the meet confer as he was obligated to in good faith. So yes, there's no comparator evidence, but I would also point out first that Boeing wasn't concerned with the fact that plaintiff spoke Farsi in a vacuum. Boeing was rightly concerned about the fact that there were communications going to Iran in the language of Iran because it's concerned about who the recipient of the information is, not because it's concerned about the birthplace of the person making the disclosures.
Let's go back to the discovery, though. So
Sure.
you say there was a motion to compel that was denied, but you also note that there was still time left in the schedule before summary judgments had to be heard.
Sure.
So why not just allow the further discovery at that point? And I guess one question is, sorry, I'm asking a bundle of questions, but would you agree that the court's reason for denying that was because of a procedural reason, because they didn't meet the Rule 26 meet and confer?
That was the reason that the motion to compel was denied. And there was a motion to reconsider the denial of the motion to compel, also denied, and with the explanation that plaintiff's counsel at the time, not counsel currently, but plaintiff's counsel at the time didn't meet and confer in good faith because he refused, despite 3 requests, to explain what it was that he didn't like about Boeing's responses, or even identify specific responses that he didn't like. So we can skip ahead to the Rule 56F request, which I think is what Your Honor is getting to. Here's what plaintiff told the trial court in terms of 56F. Needed to depose 3 witnesses. But plaintiff's counsel had already deposed 2 of those 3 witnesses, one of them twice, and had been given the opportunity to schedule the 3rd, but didn't do so. Plaintiff said, well, I need a delay in order to meet and confer. But what he was really asking for was another chance to meet and confer because he didn't do so in good faith the first time. In other words, plaintiff had time to take depositions, serve 2 sets of written discovery, receive responses in thousands of pages in documents, file a motion to compel, which was denied because he didn't participate in the meet and confer in good faith. Plaintiff had sufficient time for discovery, but he presents no authority that Rule 56F can be used as a second chance to make better use of the time that he had. Indeed, the only...
Can you refresh my memory of the record? In the motion for the continuance, after identifying the discovery that he continued to seek, was there explicit reference to how that discovery was going to help him establish a genuine issue of material fact?
So I would say that there was a mention of I need comparator evidence. Okay. So in that sense, yes. But I would also say this. The Rule 56F motion provides a to-do list. Here are the things I still want to do. But there's absolutely no explanation as to why I haven't done it already. And I would say that the summary judgment timing should not have come as any surprise to plaintiff. In May of 2023, plaintiff stipulated to a summary judgment hearing date of September 29th, which was then even extended to November 3rd. Since June of that year, plaintiff knew that the discovery cutoff was also in early November. But plaintiff didn't even serve the written discovery that's in question until August, and then, of course, failed to explain why he wasn't happy with the answers that he got. So, plaintiff's argument on appeal seems to really boil down to, well, the trial court could have given me more time for more discovery without affecting the trial date. But that's not the standard for Rule 56F. And it's also not an argument that the plaintiff made to the trial court in the Rule 56F request. So I think the court has already indicated that there's no valid theory for saying that Boeing had to give a warning to plaintiff, save him from himself rather than continue to investigate. On the issue of how it treated others on that point, there's also no evidence that Boeing gave people warnings and then stopped investigating them either, much less because of national origin. All we know is, yes, some people didn't get discharged for every violation. But that's not an admission of a deviation from the policy because the policy itself provides that there may be aggravating factors which lead to a harsher result, including discharge. And there's certainly no evidence that that was applied differently with regards to national origin, which, after all, is the issue in the case. I would briefly like to touch on the public policy claim, which is just to say there's no evidence in the record that anyone on the SAR committee had any knowledge or any suspicion that plaintiff had ever made any complaints about anything. And because a decision maker cannot be motivated by information that it didn't have, that means the claim fails on causation. Again, the claim also makes no sense because plaintiff has admitted that he's been making the same complaints for years, and yet his career continued to flourish, right up until the point Boeing uncovered all of this misconduct, which is the answers the when and why questions for this discharge. Moreover, his personal opinion about how many inspectors are enough is not anything that demonstrates a clear mandate of public policy. It's just his opinion. And the only relevant citations that plaintiff has given the court on this point, the Martin case, supports the idea that a personal opinion about what might be better for safety does not constitute a clear mandate of public policy. I thank the court for its time and ask that you affirm summary judgment.
Thank you, counsel.
Thank you, Your Honor. I'd like to address Judge Hazelrig's question at the outset. The authority is Davis 140 Winnap at 458, and what that says is the test for disparate treatment. The test is whether a jury could find that the employee is treated, quote, less favorably in terms or conditions of employment than a similarly situated non-protected employee. So that a jury could find that monitoring his secretly, covertly monitoring his behavior, taking a screenshot of his computer every 3 seconds is less favorable than other similarly situated employees. Employees were not subjected to that sort of monitoring because they weren't communicating with persons in Iran and Boeing could be subjected, could be motivated by its discriminatory animus towards persons of that national origin. I'd also like to point out, on discovery issue CP 1631, 793 to 98, 1630 to 32, these are places where Jahanbin explained what he was looking for in terms of the comparator data. It was explained to the court, Your Honor. And there was plenty of time, again, 5 weeks till the discovery cutoff, 7 months until the dispositive motion deadline. Boeing admitted at CP 996 that discovery was ongoing and productions would be supplemented. There's simply no reason to rush this to the deadline under these circumstances. And I do want to address the termination violation of public policy issue and explain one thing, that the counsel gets wrong about the record here is that he had a long career at Boeing, and then late in that long career, he transferred to the commercial aviation industry, and that's when he began speaking out about, in light of all the well-documented safety concerns that Boeing was going through at the time, his concerns about, he was specifically on the team that, removed these safety inspections from commercial airlines, and that's when Boeing, again, on an anonymous tip, started covertly monitoring and all that. And counsel also talks about aggravating factors. Those are to me, that sounds highly subjective, and subject to highly pretextual applications, and a jury should assess the credibility of whether those aggravating factors really motivated Boeing or whether it was substantially motivated, at least in part, by something discriminatory. Thank you, Your Honors.
Thank you, Counsel.